The significance of the Supreme Court's decision today is huge for Indian country. Not only do we get to keep our children, protect them, keep them in our communities, but the foundations of tribal sovereignty have also been protected.
The U.S. Supreme Court issues a landmark decision protecting Native American rights by upholding a law designed to remedy past abuses. The law prevents state welfare agencies from separating Native children from their families or tribes for fostering or adoption. But as one observer put it, the case was about a lot more than just kids. Joining us now from Tahlequah, Oklahoma, seat of the Cherokee Nation, is Rebecca Nagle. She hosts the This Land podcast, is a regular commentator on Native American rights, and has followed this case for 4 years. Welcome to Square Off.
Thank you so much for having me.
First, I'd like you to start by telling our viewers about your podcast. It's unique.
Yeah, people can listen to it wherever they get podcasts. It's called This Land, and the second season is really an investigative dive. You know, the Supreme Court's recent ruling comes after a decade of special interests that included right-wing groups, corporate lawyers, and private adoption attorneys mounted a concerted attack to get ICWA struck down. So in the past decade, this law that, a lot of people haven't heard of was challenged nearly as many times as the Affordable Care Act. And what many legal analysts and Native advocates observe is that the legal arguments in this case threaten not only this one law, but really the foundation of tribal sovereignty. And so the attacks on ICWA were seen as a vehicle to mount a broader attack on tribes in the United States.
And we'll get to that big picture, but as you say, a lot of people don't even know about this law, the Indian Child Welfare Act, known by the shorthand of ICWA. What does the law do?
Absolutely. So ICWA was passed by Congress with broad bipartisan support in 1978. And that was after a big national survey found that between a quarter and a third of all Native kids had been removed from their families and tribes. And so ICWA is a complicated law. It does a bunch of different stuff, but basically it's like a set of guardrails so that when a child who is either enrolled in a tribe or eligible to be enrolled in a tribe enters foster care or private adoption proceedings, ICWA makes it harder to separate that child from their family and from their tribe.
So how did this case we're talking about now make it to the Supreme Court?
Yeah, so it started all the way back in 2017. A white evangelical couple living in the suburbs of Fort Worth named Chad and Jennifer Brackeen had been fostering a Cherokee and Navajo toddler. When that child was available for adoption after the rights of his parents were terminated, one of his tribes, Navajo Nation, found a Navajo home. And that's where, according to ICWA, the tribe should go. The Brackeens sued, and they actually sued in family court with the help of a corporate law firm and the Attorney General of Texas. And what happened is basically they won custody. They won custody pretty quickly because they had this huge legal arsenal at their disposal. But the same week that they found out that they were, the barriers to adopt this child had been lifted, they filed a lawsuit in federal court saying that ICWA is unconstitutional because it discriminated against them as non-Native people because it wouldn't let them adopt the toddler. And so it has spent years working its way through the federal courts like court cases do, and ultimately wound up at the Supreme Court.
And so did the Supreme Court rule on the constitutionality of the law?
Yeah, so the Supreme Court made a couple rulings. There were a couple really big arguments in the case. So the first big argument was whether or not Congress has the power or the authority to pass a law like ICWA in the first place, or if really, what happens in these kind of child welfare proceedings should be up to the states. And the Supreme Court, for a lot of different reasons, said, yes, Congress has the power to pass a law like ICWA. There was another big argument, and that big argument was this idea that ICWA discriminates based on race. And what the Supreme Court ruled on that issue is that the plaintiffs didn't have standing. And standing is a legal term that basically means you have the right to bring a lawsuit. And so, instead of losing custody and then appealing that loss and bringing a case from an actual like adoption proceeding, the underlying adoption proceedings in this case were all settled. They were all done. And so instead the plaintiffs, brought this case in federal court, and the Supreme Court said basically, you can't do that. You can't sort of bring an abstract legal dispute. You have to have what a lot of people call controversy or a real conflict. And so the plaintiffs were sent away because they don't have standing.
The race issue has been prominent in this case over the last several years and different variations of the case. The Phoenix-based Goldwater Institute, an advocate for conservative/libertarian causes, has led the legal assault against ICWA in the courts over the last 8 years. I'd like you to respond to what a Goldwater lawyer told PBS NewsHour about the law. Let's listen to that bite.
ICWA is itself systematic racism against children who are at the greatest risk of any demographic in the country.
Systematic racism, and one of the narratives has been that, look, there aren't enough tribal families out there to take these kids. You have willing white families or other families who can do it. What's your response to that?
Timothy Sandifer is not the first white man to say that he knows what is best for Native children better than Native people ourselves. There have been generations of white people who've come along and say, we know what is best for Native kids, and it's this. And that kind of hubris is how we got programs like what led to ICWA in the first place, where Native kids were being systematically removed from their homes and adopted by white families. It's also how we got the tragedy of boarding schools. There were white men like Henry Pratt who thought that they knew what was better than Native people. And so I think we always, when non-Native people say that Native people don't know how to raise their own children and that white people know better, I think we always need to take those kinds of arguments with a lot of caution and a lot of suspicion. And I would also just say that, in this case, all of the national leading child welfare organizations weighed in on the side of ICWA.
Let's now pivot to what you talked about at the very outset, the bigger picture here and how you think this court case fits into that. I was struck by what one observer said, I think it was on your podcast, that this case is about a lot more than just kids. What did he mean by that?
Absolutely. And so I kind of alluded to this before, but those big constitutional arguments that ICWA is racial discrimination and that Congress doesn't have a power to pass a law like ICWA in the first place. If the Supreme Court had ruled for the plaintiffs on either of those issues, it would have been like a bomb going off in the legal structure that defends the rights of tribes in this country. And so a whole host of laws treats Native people differently, tribes and tribal citizens differently. And so if ICWA is racial discrimination, well, what about, the clinic where I get my health care? What about tribal casinos that can operate where non-Native casino developers can't? If Congress doesn't have the constitutional authority to protect Native kids, does Congress have the constitutional authority to protect our land, our water rights, our way of life? And so, the fear with this case was that it was sort of like the first in a long row of sort of upright dominoes, and that if they could get ICWA to fall, they could topple everything else. And so that was the fear that Native advocates and lawyers and tribal leaders had going into this case. And, the Supreme Court decided that, now is not the time to do that.
Have to end it there. Rebecca Nagle, thank you so much for your insight.
Thank you so much for having me.